That's us. So as I say, we're going to look at some recent holiday pay changes. Each of the kind of topics that I go through, I'm going to go through quite quickly. It's really just to put them on your radar and highlight that maybe that's the thing to check. But what I've done with today's session is I've drafted quite a lengthy, detailed blog post to sit beside it. So that means although we're going through a lot of these high level and just highlighting them, if you do want to spend a bit more time actually looking through this with the recording, there'll be a link to like a longer blog post with like full information so that you can read it and spend a bit of time going through it. So the first thing worth highlighting is that over the past decade, you'll maybe be aware that there's been a string of case law going through the courts, the tribunals, about what should be included in holiday pay calculations, what elements should be included in that calculation that you do. Now, most companies have implemented this now. I think these cases have been going on for since about 2012. So, over the last decade at least, these have been developing. So most will have these implemented, but still do come across the odd company, perhaps new member, who's still paying their holiday pay on basic salary only. So I've listed there the types of payments that have been found in case law to be inclusive in a holiday pay calculation. So that's things like commissions, bonuses, overtime pay, where that overtime's worked regularly, and that can be guaranteed or voluntary overtime, performance bonuses, and then any sort of enhancement you make to pay for being on call or on standby would be included in the weekly pay that you use for holiday pay calculation purposes. Now, as I say, this has been developing over the last decade, so tends to be in place. But if you are still paying holiday pay on basic pay, well, have a look at why it's important. You maybe look to rectify that now. I think in the past there've been almost a kind of wait and see approach developed by some employers, whereby maybe they don't pay it inclusive of these things, um, and they're waiting to see if there's any sort of complaint raised by an employee, if the pay is generally accepted by the workforce. But when we come to the end, I'll come back to that point on why that approach going forward, will be more risky. Off the back of that string of case law as well, just on the point of holiday pay calculations, they actually put some of the principles that came out of that string of case law into UK legislation with the Employment Rights Regulations in 2023. And these actually amended the working time regulations. And you'll see the 3 points below, put some of those pay elements that came out of case law into UK law. So you'll see there it says that your week's pay for the purposes of calculating holiday pay should have any sort of commission linked to carrying out contractual duties, any payments that you might make that relate to length of service or the qualifications that employee has, as well as regular overtime and any other variable pay within the previous 52 weeks. I've seen a lot of discussion on whether annual bonuses would be captured under these three headings that were added into the working time regulations. And it seems at the moment that position is unclear. There's not been any sort of case law to test that, and the general consensus seems to be that that would go against normal and historic practices from employers. So I don't think any employer is excited to be the one to add annual bonuses into the calculation. So it does seem to be that in general people are waiting for more cases to go through the tribunal where this is tested and we get a definitive answer on whether an annual bonus will fall under this. Some practical points in terms of the holiday pay calculation with all these pay elements. It would be average weekly pay from the previous 52 weeks, worked 52 weeks, include the kind of regular elements we've just went through. And another interesting point that is that it applies to the first 20 days of leave, which we now refer to as Regulation 13 leave. And that's the leave that derives from the Working Time Directive. In practice, many employers will apply these enhanced rules and apply the overtime commissions, bonuses to the full leave entitlement, to the full 28 days or however many days that employer offers, just for administrative ease, I suppose, rather than applying different rules to the first 20 days versus, the remaining days of the entitlement. And we'll take a closer look at some factors that impact that, the payment of, different rules to different days of leave next. I don't know if anyone remembers last year the horrible breakfast briefings webinars we did on the composite holiday pay rules that came out of the Agnew case. But it is worth mentioning because that has been recent as well and might not be something that you've got incorporated into your policies, handbooks yet. So the historic approach was always that employers could have different rules for the first 20 days versus any remaining leave entitlement. That might be for, as I've just mentioned, applying only the rules on the enhancements, inclusive of overtime, the first 20 days. It could also be things like, limiting any carryover of sick leave, holiday that could be taken from sick leave to just the first 20 days. But what the Supreme Court ruling in the Agnew case did, was it said that all leave is a composite pot, meaning rather than leave being in like distinct categories. So your first 20 days of the Regulation 13, the Working Time Directive leave, and then the further 8 days required by UK law, and then any remaining contractual leave if you offer over and above 28 days, rather than that being like 3 distinct categories. Each day of leave is made up of a percentage of that Working Time Directive leave, a percentage of the additional UK days, and a percentage of any leave over and above that you offer as a company. That is quite complex. And off the back of the ruling in Agnew, it, it the calculations that meant you had to do as an employer, I think there was like no payroll or HR system in the UK that had that capability to calculate it in that way. So it was complex at the time and still complex. So that means it becomes difficult to apply different rules to the first 20 days if every day of that leave is made up of a little bit of each. Generally, the position and something that can be quite helpful for this is in your contracts of employment or in your handbook as well. If you can add a statement that says the first 20 days of your leave will be treated as Regulation 13 leave, the next 8 days will be treated as Regulation 13A days, that's the UK days, and any remaining leave you have beyond that is contractual leave. That actually means that in your contract there's provision for the order in which leave will be taken, and then that then makes it easier for you to apply those different rules to different types of leave. So I think if you are an employer who does limit things to the first 20 days and you don't have a statement like that in your contract, in your handbook, I would have a look at it, get in touch and see about getting some provision just so that if there is an issue, you don't get caught by these horrible composite calculations. And as I say, the longer note I've put out, will go through this in more detail because I appreciate it's a very complicated concept for a slide, but it's all in that as well. The next change that employers might have missed is that we saw some changes last year on rolled up holiday pay. So rolled up holiday pay is where rather than pay the holiday pay at the time the leave is taken, in that pay period, you'll pay a percentage on top of basic pay over the course of the year to represent the holiday pay entitlement. So based on the minimum 28 days, 5.6 weeks of leave, that percentage would be 12.07. And that was historically ruled unlawful, an unlawful practice in the UK. But we've seen recent regulations actually reverse that and say that it is lawful, but only in very specific circumstances. So that would be if it's an irregular hours worker. So the amount they work each pay period varies month to month or week to week. And part years workers. So I think the best thing to do here is that if you do pay any sort of rolled up holiday pay, it's good to take advice on the way your scheme operates, just to make sure that the people who are in receipt of it fall into these two categories, irregular hours or part year. Now, in terms of why this is important, as I say, people may have things in their practices that are historic but not quite in line with recent changes that have come out through case law or recent legislation. But employees might be happy with the way that they're being paid holiday pay, so there's been no complaints. So it goes back to that kind of wait and see approach that I mentioned at the start of the session. But one of the things that's going to be established by the Employment Rights Bill, but I think we're maybe not talking about so often, is the establishment of the Fair Work Agency. Now, I've seen a lot of people actually liken this to the HSE, but for employment law enforcement, because that is essentially, it's going to be similar in remit. The Fair Work Agency's said to be coming in April 2026, but we don't know in April 2026, if it will be fully up and running, actually out doing inspections, compliance checks with employers. But from then, they will be established, and they actually do have the power to enter and inspect workforces and demand complying evidence that you're complying with the law. So that might be things like, asking to see your payroll system, your holiday procedures to make sure you're paying holiday correctly. And I suppose if you're an organisation who perhaps isn't including things like the overtime bonuses into your holiday pay, you could be issued what they're calling a notice of underpayment. I think what's interesting here is it's not limited to 2 years, a 2-year backstop, like currently in an unlawful deduction from wages claim. It's currently saying that it could be going back 6 years. So you'd be issued a notice of underpayment, required to pay any employees who have been underpaid the wages owed. But on top of that, they can also impose a penalty of up to 200% of the unpaid sum per worker. There is provision in the Employment Rights Bill that there'll be some sort of discount possible if you pay promptly. So they've said within 14 days. So you could get that figure reduced. But I think it's quite substantial powers, and it's pretty different from anything we have just now. So really going forward in the future, when the Fair Work Agency's up and running, we're not really at the peril of employees noticing these things. We could be subject to an inspection from the Fair Work Agency at any point, who could pick up on these things. I've also seen that they have a power to raise claims and things on behalf of employees. So I think this will be quite substantial when they're up and running, fully fledged. Another very interesting point to mention is that I just said how unlawful deduction from wages claims, which is the most common claim raised by an employee for unpaid holiday pay or underpaid holiday pay, is limited to a backstop of 2 years. And that came from a ruling in a previous case. They said that if someone does go forward and say they've been underpaid holiday pay, they'd only be able to look back at the last 2 years and be paid for that period. But there's been a case, Asher against Addison Lee, and a first-tier employment tribunal ruled that the decision about that 2-year cap was ultra-virus, so unlawful. It was inconsistent with the way Parliament intended the law to work. So that decision has been appealed to the Employment Appeal Tribunal. And what's interesting here is that if the Employment Appeal Tribunal agree with this, that then becomes binding because it's not just a first-tier tribunal, it's a decision from the EAT. So that will then, scrub that 2-year backstop that we're used to, meaning that any claims for back pay or underpaid holiday could go back many years. So another thing that heightens the risk, it's almost a kind of perfect storm. So I appreciate I've just ran through a lot of that quickly. As I say, there'll be a more comprehensive kind of note that follows. But I think the key takeaways and things you can be doing just now before all of this comes into force is have a good review of your holiday pay calculation, how you're paying holiday pay, what's included, just to make sure that it does have all of the elements that it needs to. I think the next one is having some sort of audit of your holiday pay processes for accuracy. Certainly members who take our legal support services can link in with us for these types of things, or whoever you take advice from. It's a good time to get things in check and make sure that everything's been paid correctly. The next one is having that review of your contracts and your holiday policy, any sort of document that contains rules about your holiday process is a good time to review that, particularly for the composite holiday points, to make sure you have those statements in about, which leave is taken first. And I suppose the last point is that, you might be an employer who thinks, we maybe are doing something incorrectly, or perhaps you're not including the overtime, something like that in your holiday pay calculation. The solution here will be bespoke per employer for how you rectify it, because obviously the goal is to rectify it in a way that has, as least risk as possible of back pay claims. So I would say, if there is an error or something like that, for every individual company, there would be like an individual solution on how best to fix that. So I think if you are in that scenario, I would recommend taking legal advice just to make sure that, we've worked out what that bespoke approach is and can support you in implementing that. So that really finishes us for today. Just a whistle-stop tour, put some things in your radar, and as I say, you'll have a longer note that accompanies this with more information on the kind of legal points that I quickly mentioned. Does anyone have any questions before we wrap up? I'll certainly hang on until the last person leaves in case you do. But if there's no questions, thank you very much for joining. Feel free to head off and start your day. And if you do think of anything, once your questions will probably come up as you start looking at these things. So I think definitely that's when to get in touch with us.
Thanks, Amy.
Thank you.
Thank you.
Thanks, that was great.
Thanks.
Thank you.
Thank you.